outside mentioning.
Partition suit, my lord. Special officer will supposed to file a report, my lord. Your lordship list the matter as to be mentioned, my lord, so that special officer submit a report and pass a constitutional order, my lord. As
What
per
is
court,
the report?
Court has directed to visit the B schedule property to locate the where about the properties, my lord. And there was some discrepancy made by the some of the dependent, my lord. So, my lord, your lordship, they have prepared a report, my lord, after held a meeting, my lord.
Name?
Fixed to be mentioned, my lord. I have served the notice, my lord.
Previous action. Defendant's witness only 10 minutes. Only for 10 minutes. Cross examination is completed. Only few questions are left.
You are for defendant.
The matter is appearing in the list as item number 17.
Next week. Next week.
My lord, may I be permitted to mention?
Papers গুলো পেলে তবে হবে না। Next month mention করতে হবে। Mention next week.
Few questions are left.
Everybody is saying January, so they're not getting the time to examine. Who is on the other side? No, who is the person? Plaintiff. Mention next week. We'll see in the month of April. Next.
My lord, may I be permitted to mention this partition suit? The interim order is expiring for your lordship's order till the end of March. May it be lifted tomorrow for extension of interim order under the mention. It is the item number 174 of the monthly list.
31 মনে হয় আসবে না, না? 31 আমরা তো বসবো 1 এপ্রিল। 28 তারিখে নিতে পারি। 28 তারিখে মেনশন করতে পারো, মান্থলি লিস্ট থেকে নিয়ে নাও। ঠিক আছে, ওকে। 28 মেনশন। On 28th you mention, we'll take the matter. 28th তো হবে না। 28th তো Friday. 1 April.
Any other mentioning?
May I be permitted to mention this matter, my lord, for corrections in the order dated 19 March 2025. What's the typographical error, my lord? The name of the advocate, man, it should be Saurabh Jana, because in the appearance the name is recorded, but in the second para, Mr. Pranit Bagh is recorded as Pranit Bagh.
It will be Saurabh Jana.
Yes, my lord. And there is another one, my lord, in the last para of this line of that para, renumbered as, my lord, it should be an IP.com number, my lord, because that's what transfer from CS.com to IP.com.
অনলাইনে প্রণীত বাগ অ্যাপিয়ার করেছিলেন তো? অনলাইনে করেননি? প্রণীত বাগ অনলাইনে করেননি?
It has to be renumbered.
Renumbered as one IP.com number, that should be mentioned.
And then what will be the number? The court will allot the number also.
Others department will not act, my lord, because they're
So what they're going to do with this order?
so that it's
No,
can be
what they're going to
transferred
do with this order? If it is coming under the division, IP division, they will give CS.com number.
No, my lord,
Then this has to be depicted in the order. And what is the department going to do? Then tell me, I will allot the number also. আজকে লিস্ট করে হয়ে যাবে। আসুন, this matter is appearing in the supplementary list. Mr. So-and-so, learned advocate, submits that the name of the advocate appearing for the plaintiff has been wrongly mentioned as Mr. Pranit Bagh, inverted comma, which should be Mr. Saurabh Jana. Mr. Saurabh Jana. In view of such submissions, let the name of Mr. Saurabh Jana, learned advocate, be read in place of Mr. Pranit Bagh, learned advocate, in order dated 19th March 2025. The aforesaid order is modified to the above extent. The other portions of the order shall remain unaltered. Any?
What is outside commercial bench matter item number 1?
Your Lordship, I appear for the plaintiff, Your Lordship. This is my application for examination on commission, Your Lordship. This suit has voluminous documents, Your Lordship, and even after.
madam.
Witness, I just want to point out that I am appearing for the defendant number 2, the only contesting defendant. It sees paragraph number 4. The reasons are perhaps
Your Lordship,
like,
this matter.
not
Your Lordship, this matter has been appearing for a.
urgent, Your Lordship, because
This, Your Lordship, this matter has been pending since 2005, Your Lordship, and this has voluminous documents.
and
Your Lordship, examination on chief had, like, it was heard on 13/5, 16/7, 29/8, 3/9, on several occasions, Your Lordship, and still it could not be concluded. And Your Lordship, the witness is 82 years old, Your Lordship. He is facing
after
difficulties.
the filing of the suit, the plaintiff did not take any steps almost for a decade, probably. So hence this issue has arisen. But I'll leave it to your Lordship.
Your Lordship,
Whatever your
finally,
Lordship
we
deems
thought that
fit,
Your
Is
Lordship.
the aged person?
Your Lordship.
Is it correct?
Yes, that is what I find from the application.
Your Lordship, even in order dated 19/9/2024, which is at page number 25, Your Lordship, this order was passed by Your Lordship, had granted us liberty to file for examination on commission.
He fell sick during
Yes,
examination.
Your Lordship. Yes, Your Lordship.
I leave it to your Lordship. But only thing, your Lordship, the plaintiff will bear the cost of the entire commission if your Lordship is allowing it.
Your Lordship, the plaintiff is ready to bear the cost.
This is an application seeking for appointment of an advocate commissioner for examination of the plaintiff's witness PW1, Mr. Probir Kumar Saha. The applicant plaintiff contends that TW1 has been examined in part, but due to his old age and various age-related ailments, particularly of major bypass surgery, he is unable to come to court to adduce his evidence. The applicant seeks for appointment of an advocate commissioner for further examination of PW1. Mr. So learned advocate appearing for the defendants. Defendant number 2 leaves the matter to the discretion of the court. Okay. Opposes such prayer. Leaves the matter to KDD. Opposes such prayer for appointment of advocate commissioner. Considering the averments made in the application, and the medical documents annexed to the application, let there be order in terms of prayer A of the master summons. Mr. Akilun. Akia Pundu. Rupak Ghosh. Swarnendu. Swarnendu to করতে যায় না, senior officer.
Sorry, Mr. Ghosh will also be very senior, Malad.
Huh?
I'm sorry, Malad. I'm sorry, Malad. I am appearing for the. Yes. I'm sorry, Mr. Ghosh, and they'll be very senior members, Malad. They're also very busy. Junior member of the bar, Your Lordship.
Who can be?
Mr. Poddar, Anirudh Poddar can be. Monish Rai.
Find out and then place the name. Huh?
Please.
Mr. So and so. Details for the other one with mobile number and all. Is appointed as advocate commissioner to for further examination of PW1 Probir Kumar Saha. The learned commissioner is entitled to remuneration কত দেয়? Is the remuneration of the learned commissioner is fixed at 3,000 gems at the first instance. The the staff who will be carrying the records is to receive remuneration 400 gems. The aforesaid cost shall be borne by the plaintiff applicant. Application being GA 15, GA com number 15 of 20 is disposed.
Kindly,
Let
I'm sorry.
the commissioner is directed to conclude such commission within a period of 1 month.
Please, my lord.
Yes, within a period
My
of
lord,
1 month.
your lordship has directed. I'll bear the Lordship, the cost at the first instance, because that will be subject to the final outcome of the suits.
Yes,
Only
first instance.
First instance.
Huh?
First
After
instance.
1 month, let the matter go out of list with liberty to mention. It is just disposed of. সুটটা আসবে পরে ঠিক আছে
Grateful, my lord. Deeply obliged.
Next.
Item number 2.
Last location, there was a direction to take a report from the registrar whether the writ of summons has been served or not to the Bangladesh.
No. Is having a seeking for a written statement. You are for defendant. It is contained in the application that no writ of summons was served upon the defendant for his reason defendant could not. And it is a statement. Dependent that one is a report as to whether who is appearing for the plaintiff? You are for the plaintiff. Who is for the plaintiff?
Oh.
You have some? The affidavit of service. Commercial Courts Act din to. What would be the time period for filing?
30 days, my lord, 120 days.
Which provision? 15. CPC টা দিন When did you enter appearance?
We have applied for certified copy on 9th of January 2024. Thereafter, we have filed our wakalat number and this application.
When?
24, we have applied for certified copy.
Previously, the application was filed? No. Yes?
This application.
Ask. Yes.
Topic Bhopali Bank only enter appearance after 9th of January 2020.
Prior to that, there was no appeal. This is an application seeking leave to file written statement in suit being CS number 92 of 2006. By the present application, the applicant, defendant number 2, defendant number 2 seeks for following orders. এখান থেকে নিয়ে নেবেন মাস্টার সামন্স থেকে it is contained in the application that the applicant was never served with the copy of the plaint at any point of time, and sorry, comma again, and a cartoon, since no writ of summons were served upon the applicant. Writ of summons were served upon the applicant. The applicant defendant number 2, upon inspection from the server of this honorable court, came to learn of the present suit and filed its Wakalatnama with competency. Para. Miss Deepika Banu, learned advocate, appearing for the defendant number 2 applicant, submits that since no writ of summons was served upon the applicant, the leave be granted to the applicant to file written statement within a prescribed period. Para. Despite service documents. Who is the learned advocate on record for the plaintiff? Service has not been affected. Huh?
Mr. Otis Ghosh. Mr. Otis Ghosh.
Serve this application.
Served
Where is that?
when we have served, he said, no, we do not have any communication with the client. Please serve the copy upon the plaintiff itself. My lord, we have served the plaintiff on 5th of February 2025.
Addressee could not be located. As it.
Communication, what Mr. Otis Ghosh has forwarded us.
The affidavit of service. উপরে দিয়ে দিয়েছেন affidavit of service filed on behalf of the applicant, উপরে দিয়ে দেবেন যেটা থাকে উপর। হ্যাঁ, এইবার affidavit of service shows that the learned advocate on record for the plaintiff Mr. Otis Ghosh by email communicated that his client is not in his contact since long back. The consignment sent to Utsav Rice Mills Private Limited plaintiff has returned to the addressee, returned with endorsement, addressee cannot be located. Inverted comma, addressee cannot be located. According the application is taken up for consideration by order dated paragraph 19th February 2025. A report was called for from the department to furnish report as to whether any writ of summons was issued and served upon the defendants. In compliance thereof, the learned registrar original site has furnished its report dated 7th March 2025. It is found that the writ of summons lodged twice, lodged twice, would not be served upon the defendants. Bearing in mind the aforesaid, the defendant is granted leave to file a written statement within a period of 30 days from the date of this order. Let there be order in terms of prayer B of the master summons. The application being GA 7 of 2024 stands dismissed. Within 30 days from date of this order.
Witness exercise number 3.
Action is fixed, but I have meeting at Calcutta at 12:30, 12:45.
12:30.
With comments to your lordship.
12:30. Kal ke witness time. Yes, Mr. Ghosh.
I don't know. 12:30 we can come.
12:30 you will cross-examine the witness. You have started cross-examining. Okay. The dot 12:30.
Yes, my witness is there.
Item number 4.
For the plaintiff, your lordship, we are supposed to file affidavit on evidence, your lordship. Supposed to
You have filed your affidavit?
Well, it's prepared, your lordship, but due to exigency of the family, exigency of the deponent, your lordship, he could not affirm, your lordship. We give only 7 days time for lordship.
Who is for the defendant?
I'm for the defendant, lordship.
Where is Mr. Gupta? He is.
Yes, my lord.
How many times this?
He is on his leg before lordship. Court number 41, your lordship.
Is there any witness to be adduced on behalf of the defendant?
Lordship, I have to take instruction from the AUR.
Because you are for plaintiff.
I'm for the plaintiff, your lordship. Only pay for 7 days time, your lordship. We will file your by this time, your lordship.
You will start your witness action or plaintiff's witness has been examined?
No, my lord.
No
Not-
witness
not
has
yet.
been.
Yes, your lordship.
On the prayer of learned advocate for the plaintiff, list this matter on witness action copy the is this matter on
Fine.
9th April under the heading witness action.
My lord, it would be on 10th, possible 10th April, your lordship.
Commercial.
Wednesday.
Item number 5.
Will be
দেখাবে কি দেখাবে প্লেনটা দিয়েছে প্লেনটা দিয়েছে
So three you have completed. Three go downs you have completed. One is Belvedere phase 1, phase 2, and Bojboj. Bojboj go down. How many are left?
There are, well, last action I have told you, Lordship, I submitted. That there are two claims are left. One is women charges, and another is office space. But I have not found any documents with any reference with regard to women charges and office space. You'll also kindly consider.
So any other go down in respect of which you have to make your argument?
Yeah, but today, women charges and office rent.
Yes.
But with regard to office rent, but I have found there is one question, 154.
Women, there are no such evidence.
But in 154, there are two items have been covered. Close, kindly come to question number 154. What have claimed in this suit?
Yes.
I have claimed rent outstanding in respect of Belvedere phase 2, Bojboj go down, Bojboj jute mill. There is some amount of office rent and payment charge. It should be women charges. There is a mistake there. Women charges. But there is, with regard to office rent or women charges, only in the plaint one calculation has been given, no document, nothing. Who's the organization?
Yes. Yes.
Well, my suggestion to that, question number 240 and 249. These are two suggestions, my lord. But my submission to your lordship is this. No particulars has been given, nothing has been proved. But this entire suit is misconceived, it is not maintainable. But these are my arguments, let them submit their case. If your lordship so desires, kindly give me one chance to give my reply.
that a money claim, simpliciter a money claim, arising out of a right to claim damages. Why, in short, Millard, if I may say, I have, Millard, given them a right to occupy my premises. And I have also, Millard, given a right to use a weighbridge.
according to the agreement of the parties, the question is not, my lord, whether it is a monthly tenancy, whether it is a lease agreement. That is not the question. Question is, what was the lock-in period? How long was the defendant given a right to enjoy the property? How long did the parties intend that the defendant will occupy the premises? If I have given the premises, my lord, for a particular period, and the defendant, without, my lord, occupying for that particular period, vacates the premises, of course, my lord, I am entitled, my lord, as a right, claim damages. Because the agreement of the parties says that one party will occupy such premises for such period. The breach is vacating the premises before such period.
Yes.
Now, my lord, I will of course, my lord, address and meet, my lord, the objection set forth by my learned friend, my lord. But before that, what has not been placed by my learned friend are the issues, my lord, settled in this matter. Kindly see the, my lord, issues which has been settled by this honorable court on 7th August 2019. The lordship will find as many as 14 issues have been settled. 7th August 2019.
দেখো অন্য একটা অর্ডার বুক আছে 7th August. Yes, yes.
Your lordship will find the issues.
Hmm.
Now, if your lordship takes the issues, your lordship will find out of 14, my lord, my burden is only limited to the extent of 3 or 4 issues, my lord. I'll just indicate, my lord, which are my issues or which is, my lord, my burden to prove. My lord, 3, your lordship will find that the suit is barred by limitation or not. Of course, my lord, it is an issue which has to be satisfied by, my lord, to the court. Because even if, my lord, the defendant doesn't take it under Section 3 of the Limitation Act, the court can question it and I have to satisfy that issue. So this is, my lord, I am taking it this to be my issue. 4 is also my issue, whether there was any tenancy agreement entered by and between the plaintiff and the defendant in respect of the go down in question. It should be go downs in question. 6 is also my issue, whether the defendant was in occupation of the go down of Belvedere Jute Mill Phase 2 even after 31st March 1978. 8 is a issue which is mixed in nature. Why mixed in nature? Because I will also have to show that whether the defendant FCI was in possession of the go down beyond the contractual term and the actual period of tenancy of the go down of Belvedere Jute Mill Phase 2. And it is also upon my learned friend to show that they were not actually in possession after, my lord, the lock-in period or the contractual period.
So why do you say that there is a breach in the agreement since
I'll just come. I'll just indicate, my lord. My lord, I'll just only placing, my lord, the issues for the moment, my lord, so as to understand what is my burden in this suit. 11, your lordship will find it is my issue. It is my burden. Whether the plaintiff is entitled to a decree as prayed for in the plaint as per the particulars of the claim mentioned in paragraph 16 of the plaint. And 13 and 14 are general issues, my lord, which. So basically, from a bird's eye view, what I have to show before your lordship or what I have to, my lord, impress upon your lordship is what was the understanding of the parties? Was that understanding fulfilled by the parties or
Yes.
or was there any breach? If your lordship sees the prayers of the plaintiff for once, your lordship will find the first prayer is decree against the defendant for such and such, and the second prayer is accounts and inquiry if necessary. So this is the prayer B is akin, my lord, to a prayer which we make in a damage suit. Because in case, my lord, I say that this is the reasonable amount. In case there is no liquidated damages mentioned in the agreement, I say that this should be the amount. And alternatively, I say that let the court inquire what will be the quantum of damages which I should be awarded. So A and B, A is 16 lakhs odd, which your lordship will find is particularized in para 16 of my plaint.
Yes. Yes.
I say that I am entitled to this much quantum. In the alternative, I have also prayed for an inquiry into the damages. Now, what has been placed by my learned friend is, my lord, the basic objections to the fact that it is a monthly tenancy. They have vacated the premises on a particular date. So therefore, they are not entitled to pay for the rest of the period, which was agreed by the parties. My lord, my point, if your lordship sees the plaint and a careful and a meaningful reading of the plaint, your lordship will find that my case is not whether the tenancy is a monthly tenancy or a lease agreement. My case is stipulated to the extent of saying that there is an agreement between the parties which consists of a lock-in period, which the parties intended. If the lock-in period is breached or defaulted by the defendant, which they have done, because before the lock-in period, they have vacated. Therefore, I am entitled to damages. Because for the rest of the period, I will be expecting that they will occupy and pay me the rent, which they have not done so. I have lost of the rent.
Yes.
Now coming back, my lord, to the pleadings of the parties. Now I'll request your lordship to keep the plaint and the written statement side by side. Now, my lord, a point has been taken. The reason why, my lord, I say so is, my lord, the point has been taken by my learned friend that most of the claims have not been proved by the plaintiff. I will show from their written statement there are series of admissions, and if there are series of admission, I need not prove those because those are best evidence.
Written statement. Hmm.
Milord, will kindly takes Milord paragraph 1 of the plaint. Now, before starting, Milord, may I just give a Milord brief background? Milord, I own Milord Belvedere Jute Mill, and I also own Milord Bojboj Jute Mill. In 1976, Milord, the defendant was put in possession of a space in a godown of Belvedere Jute Mill, along with an office accommodation. Parties agreed, Milord, for a rent. Number one. Secondly, parties agreed for a period, Milord, for which, Milord, the defendant will occupy the premises. After that, Milord, an additional space was provided in Belvedere Jute Mills, which, Milord, the parties have now, Milord, said in their pleadings as Belvedere Jute Mills Phase 2. Over there, Milord, also parties intended for a particular remuneration, and Milord, also the time period. Apart from that, there is also, Milord, Bojboj Jute Mill, for which, Milord, again, rent as well as, Milord, for a particular period. And, Milord, in addition to that, weighbridge, Milord, were being used by the defendant, for which they were supposed to pay us some rentals.
This is only in respect of Bojboj, Weighbridge.
This is Belvedere as well as Bojboj.
So Weighbridge is also in
21. Belvedere.
No, the Weighbridge, that is also in
Belvedere.
Belvedere. Oh. Yes.
So my claim arises out of, Milord, the entirety of Belvedere Phase 1, office accommodation, Phase 2, Bojboj and Weighbridge. Now kindly takes, Milord, paragraph 1 of the plaint for once. At all material times, the plaintiff was and still is the owner of Belvedere Jute Mill situated at Chakrel Railway Sliding and Bojboj Jute Mill situated at Bojboj Railway Station, both outside the jurisdiction aforesaid. There are several godowns within the premises of the said jute mills. Now kindly vis-a-vis this, takes, Milord, paragraph 1 of the written statement. No denial. It only says that
yes.
It only says that anything contrary to the records he denies, but accepts to the fact. Now kindly takes, Milord, paragraph 2. On or about 12th March 1976 at Calcutta, within the jurisdiction as aforesaid, the plaintiff agreed to let out the defendant and the defendant agreed to take on rent, shed and go down and office accommodation. Kindly takes, Milord, marks is what? Rent, shed and go down along with office accommodation in the premises of Belvedere Jute Mills, hereinafter referred to as the Belvedere Phase 1, inter alia, on the following terms and conditions. Kindly takes, Milord, what are the conditions? Area of the godown was such and such square feet. Office accommodation was such and such square feet. Rate of rent was fixed at rupees such and such on the basis of 33 paisa per 100 square feet. And rupees 1 for the office accommodation. Period of tenancy. This is important. Period of tenancy, 2 years from the date of taking possession, with an option for a further period of 1 year on the same rent and terms and conditions. So basically, what my learned friend was trying to impress upon your lordship is that he says that I have asked question to the witness saying that whether there are documents for which the option of the defendant was there. Your lordship will find that there is a basic difference between, Milord, extension and renewal. My case is extension, not renewal. In case of a renewal, under, Milord, in law, there is a requirement of a document, a formal document to be executed because terms and conditions will not change. For extension, it doesn't require. It could be by conduct. Because of the simple reason, extension meaning that all the terms and conditions of the agreement which is subsisting between the parties will again, my lord, be extended by conduct. So period of tenancy is 2 years from the date of taking possession with an option of further period of 1 year on the same rate. This 1 year and the 2 years are, my lord, the lock-in period of the parties. First was 2 years, and thereafter, if you do not vacate after 2 years, it will be considered as 1 year. The lock-in period will be 1 year. 1 month's rent to be deposited as initial deposit adjustable in the last month of the tenancy. Month of tenancy is to be reckoned from the date of possession by the defendant. The plaintiff would allow the defendant the use of its weighbridge, the charges for which would be the same as per the rates charged by message such and such from time to time. Now, vis-a-vis this, kindly takes, my lord, paragraph 2 of, my lord, the written statement. With reference to paragraph 2 of the plaint, and the defendant states that the plaintiff in letter number such and such, this has been marked as an exhibit, offered a go down space are stated to be approximately such and such. Some of the relevant clauses therein were as follows: beside what had been stated in the plaint. Kindly marks this. So he is accepting to the fact that there were certain terms and conditions which the plaintiff have enumerated in its plaint to some. Apart from those, the plaintiff thereafter, my lord, says that these were the additional conditions of the parties. What were the additional conditions? The plaintiff shall allow the defendant the use of the railway sliding. Next, all repairs would be carried out within 45 days from the receiving of security deposit and advance rent from the defendant. It was also stipulated in the plaintiff's letter of offer dated such and such that the rent for every month will be paid within the first week of every month for which it is to be paid. In the said letter, stipulation was made as stated by the plaintiff that the tenancy is to be reckoned from the date of possession of the space by the defendant. In the letter dated such and such, the defendant stated that the month of tenancy was to be reckoned from the date of month of taking possession of the godowns. It may also to pointed out that the actual amount of rent per month comes to rupees such and such on the basis of the calculation. The terms and kindly marks this. This is very important. The terms and conditions of the agreement will appear from the aforesaid letter dated such and such, and anything contrary thereto is denied. So he accepts and acknowledges and admits to the terms and conditions which is there in the letter dated 12/3/1976. Now kindly takes, my lord, the letter dated 12/3/1976, which is exhibit C.
Exhibit C.
Lordship will find this is there in the judge's brief of documents, DD1. Has my lord got it? Yes. Your Lordship will find that this is a letter dated 12th March 1976, issued by us to the Food Corporation of India. Kindly takes, my lord, the subject, go down space measuring approx such and such square feet at Belvedere. This has reference to the telephonic conversation the undersigned had with you with Mr. Moitro, when he confirmed that you have received confirmation from New Delhi to take Belvedere go down space on the terms and conditions mutually agreed upon. The said terms and conditions are as under. The rent is 33 per 100 square feet. 2. This is you shall have to be deposit 1 month's rent as fixed deposit, adjustable in the last month of your tenancy. Beside this, you shall have to pay as 1 month's advance rent at the time of your handing over possession to you. You shall have to pay us the rent for every month within the first week of the month for which it is to be paid. In order to enable you to pay rent within the first week, we shall be sending you our bill within the third week of the preceding month. 4. The lease would be for a period of 2 years. This clause is very important because we are ultimately relying upon this clause. The lease would be for a period of 2 years with an option for you to renew it for a further period of 1 year on the same rent. So the word used is probably renew, but it has to be extended because these are these people who have issued this letter is not lawyers. They are not expected to use the correct abbreviation. You shall have to vacate the space at the expiry of the lease agreement. If, however, you wish to occupy this space for a further period of, you shall have to enter into fresh negotiate with us for the terms and conditions. This is subject, of course, to our being in a position to rent out the space to you. Now, kindly see, this clause is self-explanatory to the extent that there are two situations. One, the lock-in period has been provided in this clause as 2 plus a discretionary one of 1 year. If after 2 years the defendant do not vacate, then automatically it is 1 year. After this 2 plus 1 year, you will find that the intent is, if however you wish to occupy this space for a further period of, you shall have to enter into a fresh negotiation. This is renewal.
It's after 3 years.
After 3 years. 2 plus 1. So what my learned friend is trying to say, that there is no document to substantiate that they were in occupation after 2 years plus the period which they were occupying, and the parties never executed a documents, is probably not the requirement under this clause. Had there been an occupation of the defendant after 3 years, then of course.
Yes.
And the intent of the parties was that they will occupy for 2 years, beyond 2 years, 1 year, of course, because that will be clarified in clause number 2.
2.
Yes. You shall have to deposit 1 month's rent as fixed deposit, adjustable in the last month of your tenancy. If my learned friend says that it is a month-to-month tenancy and I have a right to vacate after a month, that was never the intention. Had that been the intention, then this clause would not have been there. Because I am receiving 1 month's rent in advance, which will be adjusted at the end of the period of tenancy. That is 2. If occupied after 2 years, 1 year, then 3 years. Now, the office of accommodation is also there. Kindly takes clause number paragraph 5 of the letter. We shall give you 1,000 square feet of office accommodation. The rent for this will be rupees 1 per square feet. We shall allow you the use of our weighbridge, charges for which would be the same as per the rates of such and such from time to time. We shall allow you the use of railway siding. All maintenance, inspection and operational cost of the railway siding will be your account. We shall, however, give you the railway siding in a running condition. We shall carry out the repairs as pointed out in your letter of event number dated such and such. We hope to complete this work within 45 days from the date of our receiving the security deposit payment and the advance rent payment from you. The repairs would be carried out during our tenancy. At the expiry of the lease, you shall have to hand over possession to us in the repaired condition in which we will be giving you, subject, of course, to normal wear and tear. So, again, I have an obligation to repair. If my learned friend says that month-to-month tenancy and there is no lock-in period, then of course repair will take some time. Then what happens after 1 month? If he vacates, for whom I will be repairing?
Yes.
Now kindly takes me, Lord, kindly confirm the above terms and condition and also arrange to pay us the security deposit as well as the advance rent immediately. The rent would start from 15/3/1976. And they say that these are the terms and conditions and they accept this letter. The terms and kindly takes me, Lord, the last portion of paragraph 2 of their written statement. The terms and conditions of the agreement will appear from the aforesaid letter and anything contrary thereto is denied.
Yes.
So, what is the admission? Admission is that the terms and condition has been recorded in a letter. He accepts to the fact that there is a letter. He accepts to the fact that there is a letter which indicates the terms and condition, and he's accepting the entirety of the terms and conditions. He accepts and acknowledges to the fact that the period of tenancy or the lock-in period was 2 years. Thereafter, a discretionary right was given to them of 1 year, after which the parties would negotiate and enter into a fresh contract. Admission to the fact that what would have been the rent. So the entirety of the admission, if your lordship considers, is my cause of action against the defendant and for non-payment of such.
Yes.
So apart from go down, there is office accommodation. Apart from office accommodation, there is also weighbridge. Next, Milord, kindly takes Milord paragraph 3. On or about 17th, I'm sorry, Milord, of the plaint.
Yes.
On or about 17th March 1976, the defendant paid to the plaintiff a sum of such and such towards initial deposit for the go down of a sum of such and such of the office accommodation in terms of clause C of paragraph 3(2) hereof. Now, vis-a-vis this, kindly have a look at, Milord, paragraph 3 of the written statement. With reference to paragraph 3 of the plaint, defendant states that ad hoc payment of rupees such and such towards initial deposit was made to the plaintiff in advance, subject to the final adjustment after carrying out joint measurement of the area. Subsequently, on measurement of the space, the monthly rent was worked out to be such and such, and consequently rupees such and such. So, admission to the extent that the rent was fixed at rupees such and such. 85,084.23. was paid in excess was deducted from the rent bill of the plaintiff from the period from 18/3/1976 to 17/4/1976. This also has a bearing, the period which has been mentioned by them. They themselves admit to the fact that I am paying rent. They cannot, my lord, probably if I may use this expression, my lord, they cannot approbate and reprobate at the same time. Their contention is it will be considered as a month-to-month tenancy. I was put in possession way beyond March 1976, and I have, my lord, vacated in the month of March 1978, 79, 78. So therefore, I will not be I will not be called upon to pay the rent. But they themselves admit to the fact that they had paid rent from 18/3/1976. Payment of rent is in lieu of occupation of premises. Though actual occupation might not have been taken, but I have given them their possession for which they have made payment.
Yes.
The plaintiff in Annexure A has shown the amount of initial deposit paid in advance as 1 month's rent as rupees such and such. The advance of rupees such and such towards office accommodation was not paid from 17/3/76 as wrongly stated by the plaintiff. The defendant took over possession of the office accommodation only on 17/11/76, and therefore the payment of rent for the months prior to such and such does not arise. The letter is a comprehensive letter. The letter says go down, office accommodation, as well as Weybridge. Kindly considers, my lord, the letter for once. Exhibit C. Five and 6.
70,000.
Paragraph number 5 and 6. So if it is comprehensive, they cannot say that though I have taken possession of the go down, but I have taken actual possession of the office accommodation much later. If it is so, it is the bounden duty or the burden upon the defendant to show that they have actually taken possession on such and such, which they have failed to do so. Nothing on record. In fact, they have not led any evidence. They have a suit. They did not take any steps in that suit. My lord, Lordship recalls, my lord, I had, my lord, submitted that that claim should be brought on record.
Yes.
Because a limitation point is involved. So they cannot take, my lord, advantage of the fact that I have, my lord, I was put in possession in the office accommodation much later, when they themselves say that they were put in possession of the go down in March 1976.
Now, in between March 76 and November 76,
Yes.
was there any communication between the parties that they are unable to?
Not on record. My lord, might be there, but not it has not been exhibited. Nothing.
No.
Let us assume, my lord, let us assume that what they are saying is correct. My lord, I say something, the letters which they say, which they accept, says the same thing which I say. The defendant says something different. So the burden under 101 of the Evidence Act is upon him. That burden has not been discharged. The onus has not been shifted upon me. The initial burden has not been shifted. It has remained unanswered.
Okay.
Now kindly takes the next portion. The paragraph 4 of the plaint. On 18th March 1976, the plaintiff made over the defendant and the defendant took possession of the godown and the office space referred in paragraph 2 and 3 hereof. To this, kindly takes paragraph 4 of the written statement. With reference to paragraph 4 of the plaint, the defendant took over possession of the godown space on such and such. Admission. But not the office space, which was taken over on such and such. Although possession of godown space was taken on such and such by the defendant, sons. Oh, sons of the some of the shades would not be utilized for storage purpose due to required repairing having not been carried out by the plaintiff to make the space storage worthy. In this regard, the defendant refers to and relies on the letter dated such and such. The carrying out of such repair to make the space storage worthy was a precondition of the plaintiff's offer. This will be evident from letter dated such and such of the plaintiff. This letter have not come, my lord. Probably it is disclosed, but not been proved, not marked as an exhibit. Contents, my lord, says otherwise. So if they, my lord, say something, a statement, is his burden to show and prove what has been stated by them.
Yes.
Now, my lord, let us assume for the time being that they have a case. They have made out a case saying that I have not completed the repairs. For that, if they were unable to use the premises, they ought to have vacated it prior to the 2 years period, which they say they were in possession. They were using the premises. They were using the godown. If it is not storage worthy, for what purpose it has been used? Because the letter says it has been given in possession to them, or rather they were put in possession for storage purpose. It is Food Corporation of India. Then what were they storing? For 2 long years. If I have not completed the repairs, how were the food grains or the other food items of the defendant were being stored? So it shows I have completed the repairs. And, my lord, I have evidence, my lord, in support of that. My lord, my witness has gone to the box and said, I have carried out the repairs which were necessary for storage purpose. And that was exactly, my lord, the terms and conditions of the parties. Had there been a default on my part, they would have automatically terminated the, my lord, agreement of the parties saying that you're not making the repairs. So therefore, it is unable for me to occupy the said premises. I don't want to sustain any loss for your default. So therefore, I am vacating the premises. They have not done so. They have not only occupied the premises for 2 years, they have also extended the time. Though not for the entire period of 1 year, but for a couple of months.
Yes.
Now kindly takes me Lord, paragraph 5. The plaintiff states of the plaintiff, my lord,
Yes.
States that the defendant in terms of the agreement between the parties did not vacate the Belvedere jute mill go down phase 1 or the office accommodation referred to in paragraph 2 hereof, and thereby exercised its option to continue the said tenancy for a further period of 1 year. Alternatively, the plaintiff states that the defendant should be deemed to have exercised this option for a further period of 1 year in respect of the said go down. The said tenancies were for the fixed period as aforesaid. The plaintiff states that under the facts and circumstances, the defendant remain and is liable to pay the plaintiff rent for the said go down and the office accommodation for the periods up to 17th March 1979. Why 17th March? 1976, in the month of March, 2 years, which will be till 1978 March. From 1978 March till 1979 March is 1 year. So this is my claim before your lordship.
Yes.
To this, their defense is paragraph 5. Kindly takes paragraph 5 of the written statement. With reference to paragraph 5 of the plaint, the defendant states that in terms of the agreement, the possession of the go down space and office accommodation was taken on hire on monthly tenancy. Inasmuch as it was agreed upon that the monthly rent would be paid by the first week of every month for which it was payable. Besides, 1 month's rent as initial fixed deposit was to be deposited by the defendant in advance at the time of taking over possession of godown space. In fact, the sum of rupees such and such was thus paid to the plaintiff as initial deposit on such and such. Subsequently, payment of monthly rent was made in advance for every succeeding month or preference of monthly rent bill by the plaintiff. The notice for vacating the monthly tenancy on 28 to 1978 was given to the plaintiff by letter number such and such dated such and such of the defendant. The plaintiff in their letter number such and such dated such and such informed, kindly marks this, informed that the godown cannot be vacated on that date under the terms and conditions, and in case the defendant so vacate, the defendant could have to pay rent even after the said date. Consequently, so my intention is very clear. Consequently, this is also important. The tenancy being reckoned in calendar month, the date defendant cancelled their earlier notice and issued a fresh notice being such and such, intimating the intention of the defendant to vacate the Belvedere jute mill godown on 31st March 1978. So, way beyond the period of 2 years. Their defense is it is a month-to-month tenancy. I say I am not on the nature of the tenancy. I say that there was a lock-in period of the parties. Lock-in period was 2 years and 1 year, which you have exercised. So therefore, you have to pay me rent for the entire period. And I will show the exhibits which has been done in this respect. The monthly tenancy period according to the kindly takes since the defendant took over possession of the godown by the month of March 1976, the monthly tenancy period according to the calendar month deemed as expired on 31st March 1978, and accordingly the vacation of the godown was actually caused by the defendant on 1978. In one statement, they say that it has started from 18th March. Now they say that no, I have taken possession on 31st March. So therefore, the 2 years period. So there is an admission to the extent that 2 years was the lock-in period or the period of tenancy.
Yes.
They say that since these 2 years have elapsed on 31st March 1978, so therefore I have vacated as on 31st March 1978. As such, the question of exercising option for continuation of the monthly tenancy on the part of the defendant did not arise beyond 31st March 1978, the date of handing over possession of the godown space of the plaintiff by the defendant. The defendant denies anything contrary to it. So this is the defense of the defendant. Nothing on record that no, there was no lock-in period. He says only that it is a month-to-month tenancy. The lock-in period 2 years. 2 years expired on 31st March. I have vacated on 31st March. So admission to the extent that there is a lock-in period. My lord, may I come back on some other day, my lord?
Okay. Mr.
Because now I will go on to, my lord, the office accommodation as well as, my lord, the other go down and the way bridge.
Mr. A.K. Chattopadhyay, learned advocate for the defendant, concludes his argument. Kamal Kumar Chattopadhyay, defendant, Food Corporation of India, concludes his argument. Mr. Devmallo Ghoshal, learned advocate appearing for the plaintiff, places his points of argument. Stop. He seeks accommodation to place his further argument. This matter on Anjan Babu, 9th April.
9th April.
সাক্ষী এসে গেছে?
Yes, sir. 3 নম্বর। Item number 3.
Item number 3.
Where is the plaintiff?
Must be outside. They know 12:30. You can wait 5 minutes for the plaintiff's advocate. I don't mind.
Wait.
I'm ready to. আপনারা জিজ্ঞেস করো না। আসছে? ওর নাম লিখতে They are on the way.
Okay. It judges on you know. आगे भी pass over up. Wait for some. ये धरने तो হবে না আর অভয়া ইয়ের দাস।
It was transferred to the original site, to the commercial division. So, he preferred an appeal, but will kindly look at the appellate court's order. At page 15 of the application, if your lordship kindly takes paragraph 6. But the last line, in the event the said application is filed, he requests the learned judge to revisit the issue. So the order of which I am seeking a recall of is at page 30. It was a consent order. My lord, I will try to demonstrate before your lordship that it could not have been transferred to the commercial jurisdiction. Your lordship is aware of those line of judgments that even by consent of the parties, by consent also the parties cannot confer a jurisdiction on a court which otherwise does not have any jurisdiction. Your lordship will kindly mark, my lord, page 13. My lord will kindly see the suit. Suit is of 2009. Wait. So the valuation of the plane. The valuation of the suit was 85.
Wait, sir.
My lord will kindly
Sir,
take
please wait. Yes.
My lord, before amendment to the Commercial Courts Act, your lordship will kindly see the specified value. Section. My lord, I have just one copy of the book, so I have just made a photocopy of it. Correct. The lordship kindly takes section I. 2-1 I. Lordship will find specified value. The lordship count, my lord, it's
1 I specified value. Yes.
in relation to a commercial dispute shall mean the value of the subject matter in respect of a suit as determined in accordance with section 12, which shall not be less than 1 crore or such higher value. So as on the date when this act came into force on 1st of January 2016, only suits which were pending and above the value of rupees 1 crore would be transferred. Oh, my lord, now comes the amendment to the act by a notification dated 21st of August 2018. If your lordship kindly takes this notification. Now this section 2I specified value is being amended. If your lordship kindly takes page 2, section 4, amendment of section 2. Lordship will find under Roman 2 in clause I, for the words which shall not be less than 1 crore rupees, the word which shall not be less than 3 lakhs of rupees. But this was to have a prospective operation. The lordship kindly comes to amendment 2, 19, my lord, applicability of these provisions. My lord, 19 at page 6. Save as otherwise provided, the provisions of this act, this amending act, shall apply only to cases relating to commercial dispute filed on or after the date of commencement. This suit was filed in 2009. So this could not have been transferred to the commercial division. Now, my lord, apropos this, Lord, I will rely on just 2 decisions. First is, my lord, AIR 1984. It's an SEC online. 1954, 1 Supreme Court cases 710. It's a very well-known case, my lord, Kiran Singh versus Chaman Paswan. Paragraph 6 of this report.
Commercial action into
আমি তো তোমাকে প্রিন্ট করতে বললাম তোমাদের। আচ্ছা 69 কেন আমি 54 বললাম? দাও ওটা দাও। 54. Kindly take that copy. Paragraph 6. Now, after amendment, it's 3 lakhs. It can be transferred provided the suit is filed after 2018, after the amendment, but not to pending suits.
But then what about 15.3?
Kindly take any suit or application, including an application relating to commercial dispute of specified value, shall transfer to the commercial division of the commercial code or subsection here shall apply. That could mean in respect of suits where pecuniary value was above 1 crore. Because this amending act makes it clear, it will apply to suits which has only been filed after the amendment. Lordship, this is very clear, my lord, from this, and I will show a Delhi High Court decision also. Because the specified value as it stood earlier was 1 crore. The specified value was reduced to 3 lakhs by the amending act, but the amending act said that this, so far as this specified value is concerned, after reduction, it will apply to suits which has been filed subsequent to the amending act. That is, I will trouble your lordship again with that notification, but it will kindly see that 19, serial 19. Save as otherwise provided, the provision of this act shall apply only to cases relating to commercial dispute filed on or after the commencement of this act. And this has been considered. Your lordship kindly takes my application in the Delhi High Court decision. Why not? We have annexed the decision, which is at page 18 of my application.
Yes.
Could not have been transferred, my lord, under 15(3). Even by consent, it could not have been transferred because the suit was below the specified line. And the amending act only applies to suits or proceedings filed after the amending act has come into force. Now, if your lordship kindly takes page 18 of my application, we have enclosed the Delhi High Court decision, division bench of the Delhi High Court. Your lordship kindly takes just before paragraph 7J, the question before the Delhi High Court.
Yes.
A short question which arises before this court is whether the Commercial Courts Amended Act, under which I have just handed over to your lordship the notification, hereinafter referred to as the amending act, would apply retrospectively to the instant petitions or not. Vide order dated 25/3, notice was issued to the High Court seeking a response with regard to the same. Now, if your lordship kindly comes to paragraph 14, this is the your lordship can ignore paragraph 14. Your paragraph 17, the court framed the question at page 26. The question that arises before this court is as to whether section 19 of the amending act will apply retrospectively to all pending suits and applications of a specified value of more than rupees 3 lakhs that were filed prior to 3/5/2018. Exactly the same question. Now, my lord, this has been answered in paragraph 26 at page 29. In the instant case, the petitioners have stated that as per the lowered specified value of rupees 3 lakhs, by way of the amending act, they are entitled to transfer of their suits to the district court commercial in wake of section 15 of the parent act, which stipulates the transfer of pending suits to the designated commercial courts. It is further stated by the petitioner that this interpretation of section 19 of the amending act would further the purpose for which the Commercial Court Act was brought in. In considered opinion of this court, the argument of the learned counsel for the petitioner does not hold any weight. It cannot be said that there is any lack of clarity or ambiguity in the phrasing of section 19 of the amending act, which categorically states that the provisions of the amending act will apply to cases relating to commercial disputes filed or after the date of the commencement of the act, that is 3/5/2018. Here, my lord, this is 2000. Further, interpreting the amending act to be retrospective in nature will affect the substantive right of the parties who have already filed their suits in ordinary civil courts before the amending act was enforced. Holding it otherwise will also lead to administrative and practical difficulties, which cannot be said to be the intention of the legislature while promulgating the said amending act. Had the legislature intended for the amending act to be retrospective in nature, there is nothing that could have prevented the legislature from explicitly specifying the same. This has been answered by the Delhi High Court.
What is the value of the suit in this?
85 lakhs.
My lord, may I say something? It is over 10. My lord has the plain before my lord. My lord have a look at
Not today. এটাকে রাখুন অন্যদিনে রাখুন নেক্সট উইকে রাখুন উইটনেসটা ঠিক আছে
It is not only a money claim. Money claim was 85 lakhs. Along with it, there is a mandatory injunction.
নেক্সট উইকে উইটনেসটা রাখুন সাক্ষীর এসছে পার্টিস উইটনেস এটা এসছে
Item number 3.
So we take it next week, huh? On 1st.
My lord, may I just file the reply? It has been served.
তাহলে করতে হবে affidavit of reply filed on behalf of the petitioner is taken on record, copy served.
Great.
On the consent of the parties, list this matter on first, obviously. Second.
Item number 3.
Miyaka. Actually, no, push. You speak English. What is your name, sir?
Tondi Poddar. Tondi Poddar.
Tondi Poddar. CHANDI.
Poddar.
Poddar. Tondi Poddar. Yes, sir.
Is it correct that despite obtaining completion certificate of the building in August 2005, the plaintiffs deliberately delayed handing over possession of the owner's allocation until 20th April 2006?
Sir, you are talking only about my responsibilities.
Answer the question, then whatever you want to say. Like a suggestion.
Not holding. I was trying to recover my dues from them. Once they agreed my dues from them, and once they agreed, I immediately gave them the possession of the unsold flats. I had no intention to
Do we recover mine?
pending dues from them.
I have no intention to testify.
I have no intention to.
I had no intention to retain or not give their position.
Retain or not give their position.
Will you agree that you were entitled to charge interest at the rate of 16% per annum on the amount of 56 lakhs advanced by the plaintiff up to 30th of June 2003 in terms of the development agreement?
My demand is
answered, then you say what.
Yes, this is what I'm saying. Yes, I know, and my demand is accordingly calculated on the same basis.
Will you therefore agree that a sum of rupees 69 lakhs 24,010,010.96 was the amount which became due inclusive of interest at the rate of 16% per annum on 56 lakhs?
Unless I have the sheet, I can.
Agree or disagree, then give you.
Sir, I cannot give an answer. I have to see the accounts. Only then I can answer your.
I am showing you page 85 of the judge's brief of documents. Please see the calculation. Please see the calculation given in the table mentioned account A. Now, can you confirm that sum of rupees 69 lakhs 24,010.96 is the aggregate amount inclusive of interest at the rate of 16% per annum on 66 lakhs as on 30th of June 2003? 85.
Sir, will you please repeat the amount?
Sir, এই টেবিলটা দেখুন।
Account A.
Account A, sir.
correction, this is a document which is their document, not proved yet. If he has to show him, then let him show him the original.
This is a table. This is a statement. There is no original. This is the original. He will either, this is a calculation, he will
Then
verify.
he has to first confront him that this is a document. Do you know what this is? He cannot just show
I'm showing it. He said, I want to see the calculation. I'm showing him the calculation.
Sir,
what is this document called?
sir, I cannot answer on the basis of this statement. My statement is attached with the petition. Only once I see that I can answer it.
Go slow. My statement is attached with the go slow.
My petition. Once I see that statement of account, I can answer it.
Is there any statement of account with the plaint?
I can give my answer.
Plaint and Manoj documents we have exhibited there.
Mr. Sen, having reference to the documents they have placed with the disclosure.
Speak slowly, sir.
Kindly indicate which is the exhibit you're talking about.
Exhibit H, if I'm not wrong. Exhibit H টাই বার করবো নালে judges brief থেকে লাগবে। Exhibit H might be in the judge's brief also. Page 81 of judge's brief.
So in page 81 of the judge's brief.
But it is separately given as exhibit H. ওনাকে দেখান। Sir.
No. My question to you is only restricted to serial number 1 of your statement at page 81 and the interest which you are entitled to charge on this amount of 56 lakhs up to 30th of June 2003. Are you in a position to say, to dispute that on the amount mentioned in serial number 1, calculating interest at the rate of 16% per annum up to 30th June of 2003, you are entitled to 69,24,010.96.
No, there is some difference in the account. I am entitled to compounded interest every quarterly, and my calculation are based on that basis up to 30th June on 56 lakh rupees.
You have completed your answer.
No, sir. So in my interest amount, therefore, up to 30th June is 14 lakhs 81,363.
Yes.
14 lakhs 81,363.
I put it to you that there is no stipulation in the agreement regarding levy of interest compounded quarterly as claimed by you.
Yes, sir. He's giving you a suggestion.
The development agreement specifies payment of interest quarterly. If a person fails to pay the interest amount, it is generally the process to compound, and Mr. Dev agreed to this proposal.
I put it to you that there is no written agreement between the parties for payment of interest compound interest. Compounded quarterly, sorry. Compounded quarterly.
Sir, I have to see the development agreement before I answer your questions.
Development agreement.
Page
number, sir.
Starts at 11.
Sir.
Yes, still to the development agreement.
Development agreement appearing at page number 11 of the judge's brief of document.
This is 5th December.
Yes.
You give the date of the agreement.
The agreement dated 5th December 2000. দেখছি দেখে বলছি
So, though nothing is specifically written about that, but it was agreed and agreed by Mr. Dev to give compounded interest every quarterly. And similarly, that MOU was signed on that basis.
Similarly, the MOU was signed on that basis.
I put it to you that there is no document signed by the parties incorporating any such agreement for payment of interest compounded quarterly. What do you say? The suggestion, you may agree or disagree.
You may agree or disagree, then give your answer.
Maybe not in writing, but in verbal, yes.
Maybe not in writing, but in verbal, yes.
You further agree that a total sum of rupees 88,51,835 comprising of payments made by the defendant of 8 lakhs, 14 lakhs 70,000, 15 lakh 24,585 and 10 lakhs, as well as total sale value of 3 flats amounting to 40,57,250 is to be adjusted towards the repayment of 56 lakhs with interest as claimed by you.
So please explain. I cannot understand your question.
The payments which you have made, payments which have been made, which you have answered, if you see your questions 160 onwards, 160 to 164, you take into consideration these payments and the sale value of the flats, then total 88 lakhs is to be adjusted from 56 lakhs and interest which you are claiming.
I do not remember the sale value. What is the sale value of the flat? I don't remember.
I don't remember the sale value of the flats.
I don't remember. But before MOU and after MOU, they have made payment of 48 something before MOU.
48
point something. I'm not 48 lakhs approximately.
48 lakhs.
48 lakhs.
48 lakhs approximate and 40 lakhs after the MOU was signed. This much payment I have received.
I put it to you that there was no document ever executed by the plaintiff and the defendant styled as MOU as you are contending.
Yes, sir. It was the MOU was signed in the office of Mr. P.K. Jhunjhunwala, solicitor for the defendant, and Mrs. Mita Dev signed that MOU on behalf of self and her husband, late Sarit Mohan Dev.
Late
Sarit Mohan Dev.
Purit Mohan Dev. Yes.
Going by your answer to the previous question, a question is I put it to you that plaintiff has received excess amount over and above the amount payable by the defendant on interest of 56 lakhs and interest on additional 10 lakhs. What do you say?
No, they have not paid anything in excess.
They have not paid anything in excess.
I suggested to you a sum of rupees 53 lakhs, a sum in excess of 53 lakhs has been paid in excess, taking into account the payments received by the plaintiff as deposed by you and the loan of 56 lakhs carrying interest up to 30th June 2003 and the additional loan of 10 lakhs with interest at 16%.
Sir, I did not get your question, sir.
53 lakhs has been paid in excess.
No, I disagree, sir.
I disagree.
I put it to you that the amounts which you are claiming in answer to question number 50 are all fictitious and not borne out from any document disclosed by the plaintiff in this present proceeding.
So, what is the
Question 50. First, say you agree or disagree, then give your answer.
Okay, sir, I want to see the.
Yes, yes. Question 50.
Yes.
Yes.
See your answer to question 50.
My
6.5 lakh on account of modification of plant RTD 2.25. এটা লেখার দরকার নেই। 2.25 lakh on account of difference of area. Referential 78,000 on account of outstanding payment of Kolkata Municipal. So based on this is the question.
Sir, 2.25 is the
No, I'm not asking you what is the amount for. I'm saying that it is not.
The amount which you are claiming in question number, in answer to question number 50 are fictitious and not borne out from it.
yes, all this has been paid by me.
Paid by me. So first say agree or disagree, then give your answer.
What I said.
I put it to you, there is no agreement in writing between the parties regarding payment of these additional amounts which you have claimed in answer to question number 50.
That is why the MOU was executed to make everything clear, so there is no dispute further.
So there is no dispute further.
Will you agree with me that the document which you are referring to, styled as an MOU, as a purported MOU, does not bear any signature either of the plaintiff's representatives or of the defendant?
No, sir, I disagree. The defendant's signature, they signed in my presence at Mr. Jhunjhunwala's office.
Will you agree with me that the possession of the owner's allocation was deliberately delayed, taking advantage of the defendant number one having suffered a serious illness and becoming incapacitated?
No, I disagree. I expedited the payment only because Mr. Sarit Monde was not well, and Sarit Monde was not well, and Mrs. Mitra Dev requested that unless you release the flat, it will be difficult to get Mr. Dev treated. So I never Dev treated. I never delayed the possession.
I never delayed the possession.
You will agree that for the period from August 2005 to April 2006, knowing fully well that the defendant number one was incapacitated, the plaintiffs have deliberately held on to possession of the entirety of the building, including the owner's allocation.
No, sir, I disagree.
In fact, I further put it to you that you have coerced the defendant number two during this period and obtained signatures on various blank documents.
No and never, sir.
I disagree. শহীদ মোহন দে আর মিস্টার দেব বলে একটা আছে। শহীদ মোহন দে, ওনার ওয়াইফ মিতা দে।
I put it to you that it was only after all the entire dues of the plaintiff was fully adjusted in September 2006 that the plaintiff issued certificate of no objection for sale of the flats comprising the owner's allocation.
No, sir. I issued the certificate of possession once the MOU was signed.
I once again put it to you that the plaintiff and the defendant did not enter into any further agreement beyond the development agreement.
Sir, I deny.
I disagree.
Will you agree that as on 30th September 2006, after receipt of the last payment of rupees 10 lakh, from the defendant, the entire dues of the plaintiff stood settled and an excess amount was deposited. Now, an excess amount fell due and payable by the plaintiff to the defendant.
No, sir, wrong. I deny, sir.
I disagree.
I suggested to you that the particulars of claim as contained in page 81, allegedly marked Exhibit H, is not corroborated from any document signed by the respective parties.
This statement is based on what is in the agreement or in due course of discussion with Mr. Dev. Nothing is out of.
Have you disclosed the payments in support of payments made by the plaintiff in support of the claim contained in serial number 2, 3, 4, and 5 of the purported document marked as Exhibit H?
Sir, point by point, I will answer the question. Yes.
But please listen to the question and answer.
Yes.
Have you disclosed the payment made by the plaintiff?
Allegedly made by the plaintiff.
Allegedly made by the plaintiff in support of the claim contained in serial number 2, 3, 4, and 5 of the purported document marked Exhibit H.
Just please once again repeat the question.
Have you disclosed the payment allegedly made by the plaintiff in support of the claim?
And documents evidencing the payments.
Evidence
Made by the plaintiff in support of the claim contained in serial numbers 2, 3, 4, and 5 of the purported document marked as Exhibit H.
Yes. Can I elaborate?
Yes. The witness for it, yours.
You want to give the page numbers of the document, you can give.
No. I have to specifically reply payment of 2.25. 2.25 lakhs. So it was a joint venture development agreement between us. And nothing can be measured and given. So this 2.25 is the value of 2.25 lakh is the value of excess area given to Mr. Dev. That is the value of the excess area. The total after the total construction area, 31% was supposed to be given to Mr. Dev. It cannot be the exact 31% when the 14 flats were divided. When the 14 flats were divided.
When the 14 flats were divided.
So this 2.25 lakhs is the amount for the excess differential area given to Mr. Dev.
Excess differential area given to Mr.
This he has answered in 170.
He's again answering. I have not asked him this. He wanted to clarify it in detail.
Now the ratio changes from 39 to 31. So you see 170 he has answered. So this will be repetition of that.
don't put your hands on the pocket.
Yeah.
চেয়ারদের কথাটা কেটে
I put it to you that the purported account relied upon by you at page 82 is based on a fictitious, non-existent document.
That I deny.
Is it?
That's it.
So you can step down and stay here. Once the order is passed, we may go.
Discharged, because I may, my lord, re-examine him for
No, then an application has to come up.
No, my lord, subject to
After-
correction, re-examination
Hey, now-
is a right that is inbuilt, my lord. I can also, if your lordship wants, my lord, I can show the law on this. Possibly, my lord, subject to correction, re-examination is a matter of right. I don't possibly require to make an application. I will satisfy, kindly keeps it 2 weeks hence. I'll satisfy your lordship on the law, and if your lordship thereafter thinks that an application is to be made, I will make that.
Sir, Sakho Sen, the senior advocate for the defendant, concludes cross-examination of witness Mr. Chondi Prasad Poddar. Mr. Rupak Ghosh, learned advocate for the plaintiff, submits that he intends to re-examine the witness, which reason the witness should not be discharged as on date. Release this matter after 2 weeks under the heading Witness Action. Mr. Chondi Prasad Poddar, witness, is directed to remain present on the returnable date. একটা পোলিও ছিল ওটা আসতে বলবো
Before rising lordship, non-commercial matter, I can for one and only for the fixing the matter, my lord.
Witness can be kept at any time. Any time if it's instead of in the morning, well, morning sometimes we get
কবে আসছে
12:30 or any time if it comes. আচ্ছা, ঠিক আছে, we'll
Very well, sir.
we'll come and jointly pray for some accommodation.
like today
Yes, right.
Your lordships have been kind enough.
Item number 1 is not commercial matter, my lord, only for the fixing the date for the witness. My lord, I have already talked to Mr. Third Lordship. 7 and 8, my lord, any date in the month of May. Lordship, it is possible, Lordship, it is possible, my lord, at 2 PM or any.
এখন ফিক্স করা যাবে না
We are agreed, my lord, 7 and 8.
তাই বলে দিন
I am for the defendant.
Yes, yes. Mr. God is over here.
not now
I am a
রাখুন
defendant, my lord.
এই মাসের ডেট দিয়ে দিন আর কি অর্ডার করে দেবো
My lord,
অর্ডার করে
my lord, my lord, they have to come from the other state from distance, and they, due to availability of the travel ticket.
হেডিং কত নম্বর 1 and 2
Item 1 and 2.
mention on the consent of the party
Any date in the May, on the May,
7th May
Any time.
my lord.
চলো
I'm deeply obliged.
Being leave to mention a matter, my lord. My lord, by an order dated 6 February 2025, my lord directed the matter will appear on 21st February. The matter is not appearing, my lord. My lord directed the state to file a report. The report has also not been filed.
Returnable motion ছিল না list for
My lord, may I permit to mention item number 23 of the today's list, my lord. Matter relates to cooperative society matter, my lord.
দাও ফাইলটা দাও হলে বার করো ফাইল ঠিক আছে
May I be allowed to mentioning a matter? This matter is running on Monday daily list, item number 133, case is 2025. There is an inadvertent formal defect in the writ petition, and kindly give a.
It will appear on Friday.
Yes.
Mention on Friday.
Mention on Fridays. Okay.
25.
130. Item number 130.
Which is the year?
Oh, 2025.
On Friday.
Okay. Thank you, madam.
আমাদের কি কোঅপারেটিভ নেই
Determination of getting panchayat. At that time, panchayat and cooperative was there. That's why.
No, group 5 is panchayat or cooperative, both. Both. Release হবে Mr. Chancholan's advocate for the petitioner submits that the present writ petition is filed under the Cooperatives Act, West Bengal Cooperatives Act, and seeks that the matter be released. In view of such submissions, due to want of determination, the matter is released from the list of this court. Place this matter before the court having determined.
If you mention matter 2024 motions matter not never appeared in the list.
Now, not 24. How many are there?
Matters.
List for.
My lord, may I be permitted to mention one matter? My lord, the matter relates to the tender. My lord, the petitioner participated in the tender without giving any reason. My lord, the tender has been cancelled. My lord, the work order will be issued soon. My lord, unless your lordship take the matter at the earliest, my lord, the matter
What
will
is
be.
the
My lord, the matter is item number 301 of the daily list. My lord, Monday daily list. My lord, it was appearing in the item number.
On Friday, it will appear.
Same cause of action.
Friday. This will appear on Friday. Motion or returnable? Motion.
May I permit to mention item number 11 of today's list? My client's instruction is not non-possible. 11. On the instruction is my lord is WhatsApp. My lord, they are not coming physically.
Get a hard copy of that.
Kindly fix it
Next week.
11.
Item number 11.
Item number 11.
On the prayer of learned advocate for the petitioner, list this matter on next Wednesday.
Next one is
24th. Huh? 2nd April. 2nd April under the non-prosecution.
May I permit
ঠিক আছে
to mention
11 2nd April to be mentioned down bracket যেরকম লেখো non-prosecution to be mentioned. This will appear on 2nd April. 2nd April.
may I permit to mention for updation lordship regarding unauthorized construction.
May I be allowed to mention? I have served the notice to the other side, Your Lordship. May I be allowed to mention one matter is for upgradation, Your Lordship.
No
The urgency is that, Your Lordship. The petitioner, Your Lordship,
No, call the list.
some extreme urgency is there,
No.
Your Lordship.
Item number 1.
Written instruction. Mr. Swainso, learned advocate for the, this matter is appearing under the heading to be mentioned. Mr. Swainso, learned advocate for the petitioner submits that the petitioner does not intend to proceed further with the writ petition. He files written instruction. Huh? Which prayer? He files written instruction dated, written instruction of the petitioner dated 23rd March 2025, which is taken on record. In view of such submissions, the writ petition stands dismissed as withdrawn. In connected applications is
Item number 2.
Advocate for the petitioner. Not difficulty. I'm only praying for not to them.
পরের উইকে কি আছে? On the prayer of learned advocate for the petition. দেখেন তারপর যেগুলো নেবে অ্যাকোমোডেশন চলে যাবে 9th.
Item number 3.
I am for the petitioner, my lord. I served upon all the respondents, my lord. This is effective. My lord, against the illegal and unlawful construction over the water.
9 to 16. State. State is there.
Let us.
Pradhan sir.
Except the matter, all this is effective upon all the.
Pradhan is at which page?
For the state.
Pradhan.
My lord, land of the petitioner. The land of the petitioners, there is a public road, my lord. Public road. One side is the.
I have a detailed report.
We are in the another side. The man out of personal grant, my lord, he filed this read application, my lord. My lord, it is a 226 matter, my lord. However, my lord.
Yes.
But this is with regard to unauthorized construction.
Let him first submit it.
Unauthorized construction, my lord. My lord, all in a water body, my lord. My lord, plot in question, my lord, reported as a pukur. That is the water body, my lord. My lord, kindly come.
Which one? Which one? Plot number?
Page number 25, my lord.
25 which plot?
776. 776 and next page, my lord. Page 26.
776 is Pukur.
And next page, my lord. Plot number 223. There is the Doba. The construction was made by the private respondent, my lord, over the said water body, that is the pond. And I have annexed some photographs, my lord, from which it is crystal clear that my contents, my lord. Being adjoining owner, my lord, I made objection before the competent authorities on 6/12/2023. All the concerned authority as per the Panchayat, provisions of the Panchayat, my lord, Panchayat Act, my lord. That application was not considered till today, my lord. Let the authority concerned be considered the dispose of the said application, giving an opportunity of being heard to all the interested parties.
Yes.
My lord, we have already done query, my lord. A hearing was given, my lord. And this is the my lord detailed report, my lord, kindly look. But the plots on which the construction have been made, my lord, is a classified pukur and a dome. So it has been affirmed that the plots on which the construction has been done are unauthorized construction.
No, my lord.
So we have
We obtained the permission from the competent authority. My lord, I file opposition, my lord. My lord, this is the plot in question is situated.
Sir, please let him complete. You will get your turn. Yes.
Hearing was given, my lord, and my lord, we have found the block land and land officer, my lord, has found that there was no permission issued by the block land and land forms officer, my lord, with regard to the construction over the classified land, which is classified as Cooperative. So prima facie, it is an unauthorized construction.
Yes.
Now, they have any grievance against the findings of the BLRO, my lord? Let them approach the proper authority.
Yes.
Already, my lord, the plot in question is situated within the, my lord, jurisdiction of the Wholesale Development Authority, it is industrial area. My lord, conversion, permission, may be taken from the SD authority. We got permission from the SD authority. My papers is here.
This is
Kindly
the
allow
report
me
they have,
to-
they have submitted details of the SDO.
Who
The
is
report
the
is filed by
BLRO?
the SDO.
Only this is not the
report
question of
filed by
BLRO.
the
No, block development office.
No, this is the report filed by the SDO, my lord. Video. I'm sorry, video has filed this. Not the SDO, video.
Without examining unless the water. Homestead land.
Where is your permission?
I have all, my lord, all deposited money, everything, my lord, got permission, my lord, kindly allow me to file, my lord, those documents. Yes, kindly allow me. I
Asun, affidavit service filed on behalf of the petition is taken on record. Mr. This writ petition has been filed seeking for demolition seeking for consideration of the representation of the petitioner dated 16 December 2023 within bracket annexure P3 by the respond numbers 4 or 5. 4 and 5 for the 4 and 5. Mr. Para. Mr. Solil Kumar Maiti, learned advocate appearing for the petitioner, submits that the work of construction has been undertaken. Offer affidavit of service to the other has been undertaken on a land classified as Pukur and Doba within plot number 776 and plot number 223 of what is the Moja? Of
Anar Nagar.
Anar Nagar.
Jail number 5.
Anar Nagar, jail number 5 by the private respondents without obtaining sanction building plan or permission from the Gram Panchayat. A representation was submitted before the local Gram Panchayat alleging of such illegal construction by the private respondents on 16 December 2023.
No representation.
However,
Before concerned Gram Panchayat, my lord. Kindly see the page 30, my lord. Page 30.
Somiti,
Representation before the Pradhan. Because the plot in question is
before the before the
concerned Panchayat Samiti, Sabhapati, Panchayat Samiti. Panchayat Samiti, no.
before the Sabhapati Sutahata Panchayat Samiti.
No representative before the Gram Panchayat, Pradhan of the Gram Panchayat.
Since no steps has been taken, hence this writ petition. Mr. Wasim Ahmed, learned advocate for the state respondents, submits that the work of construction has been undertaken without permission taken from the Gram Panchayat over plots of land which are classified as Pukur and Doba respectively. he files a report of the block development officer, Sutahata block development block, which is taken dated 25th March 2025, which is taken on record. Yes, madam. Ms. Nilanjana Addo, learned advocate, appearing for respond number 8, officer in charge, Sutahata Police Station, submits that the entire dispute is civil in nature. Mr. So-and-so learned advocate, appearing for respondent numbers 9 to 16, submits that such work of construction has been undertaken by with permission from the concerned authority. He seeks to file affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of 2 weeks from date. A reply, advance copy of such affidavit in opposition be filed within to the learned advocate for the petitioner. A reply thereto be filed within a week thereafter. Release this matter after 3 weeks under the heading returnable motion.
Copy of the report may be handed over to the
State learned advocate for the state respondent is directed to serve a copy of the report upon learned advocate for the petition. Why?
My lord, if both of them are asking for. Yes, my lord.
Without annexures, okay.
My lord, a copy also be handed over.
To give it to the respondents also. To learned advocate for the petitioner as well as requisition. Private respondents number 9 to 16 দেখে নিন ঠিক আছে মিলিয়ে নেবে মিলিয়ে দেখে নেবে ঠিক আছে ওই রিপোর্টে থাক after 3 weeks.
Item number 4.
Who is this person? 9395. 9395. Shopon Das, not served. Six 938. And 38 is Taposh Das, sir. 6938, sir. 9130. Swabadipati, not sir. Phone. This one number 11 and 4. 9276. 9259. One. 9276. I press upon respond number 11 and Respondent number 4. Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service upon state has been served. Service upon respondent number 4 and 11 has not been effected. Petitioner is directed to serve a phrase upon respondent number 4 and 11 through registered speed post with acknowledgement due and file affidavit of service on the returnable date. When it can be completed? 10 days. Is this matter? 10 দিন পরে এটা 24 ম্যাটার কখন আসবে?
24 ম্যাটার আপনি বৃহস্পতি
9th April. Motion.
Item number 5.
For the state exposure. But I'm appearing on this.
Any private respondents is here?
There, my lord, the matter pertains to recover
Pradhan.
overdraw.
Huh? Take the microphone, sir.
Matter relates to recovery of overdraw from the retiring gratuity of the employee, which is wholly impermissible in terms of the directions of the orders of the judgments of the Honorable Supreme Court of India in Rafiq Masi's case. That the state is the appropriate authority to
State.
Yes, madam. The state is the appropriate authority. The answering respondent.
Item delivered 9500. Director of Provident Fund.
Yes, I've someone is covered under the your state, but apart from that, I have also served upon him too. That is his page 5. The postal receipt is annexed.
Okay.
The top one is the Director of Provident Fund, and the bottom one is the Pradhan.
Yes.
But the petitioner who is before your lordships was working as Nirman Shahayo. Now, my lord, he retired on 31st of December 2022. Now, my lord, while he retired, it was found that an amount of overdrawal at page 18, your lordships may kindly seize. The recovery amount has been given there at page 18, 1-8. Yes, ma'am. Now, lordships may kindly seize the first table, deduction due to salary overdrawal, recovery head of account, and to the extreme right column, the amount is there 176,297. Now, this was sought to be recovered. Now, your lordships may also kindly seize the release order at page 21. In pursuance with memo number such and such, dated, issued by the Block Development Officer, Purulia 1, Development Block, Santosh Kumar Dash, Nirman Shahayok, Pandarpura Chipida Gram Panchayat, is hereby released today, 31st of December 2022 in the afternoon from his service due to superannuation after attaining age of 60 years. Now, it is therefore no more in dispute that after I retired, the state found out that yes, there is an overdrawal which I have to repay. Now, the only option which was left to them was they stated that you give it to us. Now, the Rafiq Masi's judgment, 5 types of conditions have been clearly stated. I have it with me. I shall be handing it over to your lordships. It clearly states that when the recovery is permissible and when it is not. Out of which the very first condition, it states that persons who have retired, you cannot touch even 1 penny out of their retiral benefits. Now, my lord, while they asked me, I stated that, see, I do not have anything else. I only have the gratuity. Therefore, my lord, they took a consent from me, stated that, see, we cannot release your salary and other retiral benefits and dues because the calculation would not be reflected properly in their portal and in their account statements or in their computers. Therefore, you have to say that you have to give this consent, and if you do not give this consent, we cannot release the retiral dues. So out of compulsion, just to receive my retirement benefits, I gave an undertaking that, okay, you are free to deduct it from the gratuity. Now, my lord, accordingly, the amount was deducted from the gratuity, and what I am beseeching before your lordships in this writ application is this, that even though I may have given an consent, but such estoppel cannot operate against the statute. Where the law is settled, I cannot be compelled to give an undertaking, or even if I give any undertaking, that cannot stand the law, because what the law has been stated, that no overdrawal from those who have retired, that is there. Now, my lord, apart from this, I shall also be relying upon one decision of our honorable court, wherein a batch of writ petitions had come up. The same issue came up much prior to Rafiq Masi, where also consent was given, but this court stated that no, whether you give consent or you do not, from the retiral benefits, nothing can be deducted. Now, my lord, ultimately the deduction was done. Ultimately, my lord, the deduction was done at page 45. Your lordships may kindly seize. The pay certificate was given. Page 45, my lord.
Yes.
Lordships may kindly seize the last part. Overdrawals of pay and allowances. Sri Santosh Kumar Das had overdrawn an amount of rupees 176,297 on account of Santosh Kumar Das, of which Ato shall be recovered up to the date of superannuation, leaving a balance as outstanding on the date of superannuation to be recovered from gratuity. That this is wholly impermissible. This cannot stand the test of law. And my lord, it is now been the settled position that no amount can be deducted at all from the retiral benefits or from the persons who have retired. May I place Rafiq Masi's decision before your lordships? And this is the, I mean, it is the settled position, and it has been now been the settled law. May I just place it, Rafiq Masi? But even my learned senior friend is saying that I am entitled to it. When he is also
submission is before lordship that page 22, annexed P4. He made a representation to the block land and block development officer.
That I have stated. That I have stated. That I have stated. But
In this situation, I pray before Lord Honor, kindly to take necessary measures for deduction of overdrawn salary such and such money 200 from gratuity, as I am unable to refund cash due to my financial strength. Malay also kindly give direction to the respondent number 3 to dispose of this.
Which one? This is a consent he has given, but he says that this is acting against the statute.
Yes, that is it, my lord. It is acting against the statute, my lord. Therefore, no consent could have been asked by them, and no consent would have been given by me also. My lordship may kindly says.
Then what is the process of recovery of this?
My lord?
What is the process to recover this?
The process to recovery is nothing, my lord. Your lordship will pass an order in terms of the judgments, and there will be a direction for refunding me this amount.
But what about the overdrawal?
Well, this is the overdrawal amount only. That will be refunded to me. Lordship kindly takes up the. Kindly takes up the Rafiq Masi's decision, my lord. Five conditions have been stated out, carved out.
No, this amount you have paid
Yes.
to have the pension granted in your favor.
My favor.
Now this is a overdrawal made by you at the time of your
Certain
in service you have made it.
increments.
No, what I am asking is, if it is not from the gratuity or any of the pension benefits, how this overdrawal will come to the hand of the government?
My lord, what happens is,
Or it cannot be redressed at all.
Like during the pay revisions,
Yes.
these mistakes happen. These mistakes happen on the part of the state government while calculating such amount.
Now it is an admitted position that a public money has been overdrawn by a officer who has retired from service. The law is clear that it cannot be deducted from the gratuity or any of the pensioner benefits.
True, my lord.
My question is how the government will recover this amount. There is no possibility.
No, the only point that could have been recovered by the government was while I was in service, and they would have recovered it prior to at least 5 years prior to my retirement.
No, once a wrong made, they have to suffer now.
Yeah, because the conditions of Rafiq Masih states that if there has been no fraud, no misappropriation, and no other undue influences, or we may say that there has been any wrongdoing on the part of the employee, it is wholly upon the government to bear. Kindly see what the Honorable Supreme Court has stated.
Para 7.
Para, yes, your lordship takes up.
Paid in excess without fault of.
This is the celebrated judgment, my lord, and this is now holding the field.
Balancing
After this, there are two other decisions have come.
recovery is directed within.
But the very first paragraph, all the private respondents in the present bench of cases were given monetary benefits which were in excess of their entitlement. These benefits flowed to them consequent upon a mistake committed by the competent authority concerned in determining the emoluments payable to them.
Where are you reading?
Under the very first paragraph, my lord.
Yes.
Page 337, very first paragraph. It's granted all the private respondents in the present bunch of cases were given monetary benefits which were in excess of the entitlement. These benefits flowed to them consequent upon a mistake committed by the competent authority concerned in determining the emoluments payable to them. The mistake could have occurred on account of variety of reasons, including the grant of a status which the employee concerned was not entitled to, or payment of salary in a higher scale than in consonance of the right of the employee concerned, or because of a wrongful fixation of salary of the employee consequent upon the upward revision of pay scales, or for having been granted allowances for which the employee concerned was not authorized. Now, the next line is very important. The long and short of the matter is that all the private respondents were beneficiaries of a mistake committed by the employer, and on account of the said unintentional mistake, the employees were in receipt of monetary benefits beyond their due. Does this satisfy your lordship's query? Now, apart from that, the very next paragraph essential factual component in this bunch of cases is that the respondent employees were not guilty of furnishing any incorrect information which had led the competent authority concerned to commit the mistake of making a higher payment to the employees. The payment of higher dues to the private respondents in all these cases was not on account of any misrepresentation made by them, nor was it on account of any fraud committed by them. Now, this also satisfies your lordship's query. Now, my lord, what ultimately the Supreme Court summarized the entire facts. Kindly takes up lordship's paragraph 18 at page 345. Paragraph 18 at page 345.
So, prior to that, you read paragraph 4.
Merely on account of the fact of the release of these monetary benefits was based on a mistaken belief at the hands of the employer, and further, because the employees had no role in the determination of the employer, could it be legally feasible?
This is my question.
Yes,
Yes.
this has been finally
Yes, you read that.
answered. Legally feasible.
What was the decision?
There was a reference made.
Yes.
Now the reference was made prior to this, and wherein the Honorable Court stated that one part of it has been passed under Article 142. Therefore, in this judgment, finally the Honorable Supreme Court has framed and given all the answers. The answers are at paragraph 18, my lord.
Including the query which is raised in para 4.
Yes, my lord. Everything.
Okay.
Everything. Paragraph 18.
18.
Or lordships, for a moment, may I just kindly beseech your lordships to kindly comes to paragraph 13 also. Paragraph 13. The second part at page 342. Page 342, my lord. 4 lines from the top.
Yes.
Yes, my lord. It is apparent that a government employee,
yes,
primarily dependent on his wages, and if a deduction is to be made from his or her wages, it should not be a deduction which would make it difficult for the employee to provide for the needs of his family. Besides food, clothing, and shelter, an employee has to cater not only to the education needs of those dependent upon him, but also their medical requirements and a variety of sundry expenses. Based on the above consideration, we are of the view that if the mistake of making a wrongful payment is detected within 5 years, it would be open to the employer to recover the same. However, if the payment is made for a period in excess of 5 years, even though it would be open to the employer to correct the mistake, it would be extremely inequitous and arbitrary to seek a refund of the payments mistakenly made to the employee. Now, lordships may kindly takes up paragraph 18. At page 345.
But here the mistake has been detected within a period of 5 years.
Yes, that is in case of the recovery could have been made while he is still in service.
When was the pay fixation made?
That can be stated best by the respondents only, my lord. But well, that would not come into picture because they have proceeded to take it from my retiring gratuity. Lordships may kindly takes up page paragraph 18.
Excess of 5 years.
It is not possible to calculate all situations of hardship which would govern employees on the issue of recovery where payments have mistakenly been made by the employer in excess of the entitlement. Be that as it may, based on the decisions referred to herein above, we may, as a ready reference, summarize the following three situations wherein recoveries by the employers would be impermissible in law. Now, the Supreme Court categorically states that if somebody falls under this category, it is wholly impermissible. My lord, I come under point number 2. Recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. Therefore, my lord, if they have sought to overdraw the amount, recover the amount from a retiring gratuity, it is wholly impermissible in terms of point number 2, in terms of this Honorable Court's decision. But this is right now governing the field.
But what about that observation of 5 years? From the date of fixation, they can recover.
But in my case, while I was about to retire, at that point of time, they have come up. And not before that. Therefore, my lord, I come that when I was retiring, you have come. You have sought to recover.
But once retired, this cannot be recovered.
No, my lord. Not they cannot recover.
Cease of 5 years. What does the pay certificate say that when was pay fixation was made? Which will be raised per month.
No, that is at the time of his retirement.
Increment for retirement in the
at that point of time. Well, it is very difficult to say, at what point of time the overdrawal had happened. The moment I retire, you cannot touch my retiral benefits.
This order at pay certificate at page 45 is after your retirement.
Page 45, my lord. Well, I find this is dated 2023. Although the official seal and date is there, but I retired in the year 2022.
Oh.
31st of December 2022. Perhaps this is after that. Therefore, my lord, my case is squarely covered by the judgment of Rafiq Masi.
Yes.
Yes, boss. This is covered with that.
Affidavit of service filed on behalf of the petitioner is taken on record. The writ petition has been filed directing the respondent, which respondent will refund this amount?
The block development officer.
Directing the respondent authorities to refund the amount of overdrawal of rupees 1,76,297. This is the amount to be refunded?
Yes,
or any other prayer?
Oh, my lord. It is the only amount.
The petitioner contains that he was posted as Nirman Sahayak in the office of at Begun Kodar Gram Panchayat under Jhalda 2 development block in the pay scale of para 2. By order of district magistrate, District Magistrate Purulia and Executive Officer Purulia Jila Parishad. VDA memo number 5449 within bracket 99/GP dated 30th May 2006. The petitioner superannuated on 31st December 2022 after rendering service of 16 years, 6 months and 27 days. After such retirement, the petitioner was directed to refund the overdrawal of rupees 1,76,297. The petitioner by his later dated, where is that later page number? Later dated,
Page 22, my lord.
later dated 31st January 2023, requested the respondent number 3, Block Development Officer Purulia 1, Block Development Office, to take necessary steps for deduction of the overdrawn salary of rupees 1,76,297 from gratuity. Accordingly, the aforesaid amount was deducted from the gratuity of the petitioner. It is contended that such deduction of overdrawal after retirement from the gratuity is illegal. Hence this writ petition. Mr. So and so, learned advocate, appearing for the petitioner, affidavit of service to the petitioner, submits that the deduction from the gratuity of the overdrawal amount of rupees 1,76,297 after superannuation is illegal, and therefore such amount has to be refunded to the account of the petitioner. In support of his contention, he relies on the decision of Honorable Supreme Court passed in State of Punjab and others versus Rafiq Masia within bracket Whitewasher and others, reported in 2015 volume 4 SCC 334. Mr. So and so, learned advocate, appearing for the state respondents, concedes to the submissions advanced on behalf of the petitioner. Upon perusal of the records placed before this court, it is found that the petitioner superannuated on 31st December 2022. Thereafter, the order of deduction is page 18. Page 18 is the order of deduction. 18, page 18, annexure P3.
Page 18. This is the
The petitioner was posted as Nirman Sahaya and had superannuated on 31st December 2022. Admittedly, after is which page?
Sir,
After
page 18 is the PPO, which shows that there has been a deduction of 176.
admittedly, there has been deduction of the overdrawal from the gratuity of the petitioner, from the amount of gratuity of the petitioner to the tune of rupees 1,76,297, which is also revealed from the e-pension pay order at page 18 within bracket annexure P3 of the writ petition bracket close.
Pension payment order.
Yes.
Pension payment order.
Pension payment order. Yes. E-pension payment order. Now it is to be examined whether such deduction of overdrawal after retirement from the gratuity of the petitioner is legally valid or not. To find an answer to the aforesaid query, it would be apposite to reproduce the proposition laid down by the Honorable Supreme Court in Rafiq Masia Whitewasher Supra as hereunder, para 18. In view of the bearing in mind the aforesaid proposition, this court finds that the deduction from the gratuity of the petitioner of the overdrawal amount ought not to have been done by the authorities concerned. Accordingly, respondent number 3 is directed to refund the retirement benefits, the refund the overdrawal amount deducted from the amount of the 1,76,297 to the, this account is a pension account.
This is will be a pension account.
Achha.
Then, my lord, let there be a joint deduction upon 3 and 4, my lord, because 4 is the pension disbursing authority. That 3 and 4, my lord, they
Okay.
jointly exercise.
Respond number 3, Block Development Officer, Purulia 1, Development Block. And respond number 4, the Director of Pension Provident Fund and Group Insurance, Government of West Bengal. They can have been ranked. Director of Pension, Directorate of Pension is directed to refund the overdrawal amount of rupees 1,76,297 to the bank account of the petitioner within a period of 4 weeks. 4 weeks from date of communication of this order. Petition, you provide the account number also to which this amount has to be within period 4 weeks from date of communication of this order. Petitioner is directed to communicate this order to respond number 3 and 4 and also provide the bank account number to which such amount, aforesaid amount, is to be refunded. With the aforesaid direction, the petition stands disposed of.
I'm so grateful, my lord, but only one thing, my lord, certain typographical error is in the petition. Typographical error is in the petition where I have stated the petitioner is a group C, but he is a group A employee, my lord.
Which paragraph?
That is in page 6, last line. And page 8, the grounds.
Page 6.
Yes.
Page 6.
Last line, one I have stated to be a group C, but he is a group A, my lord. But I may be correct.
On the prayer of learned advocate for the petitioner, leave is granted to correct the category of the petitioner in the in page number 6 in para 9 and
Page 8,
at ground number
round number, my lord, 5.
ground number 5 page. হ্যাঁ ইন্টারেস্ট পেয়ার করছো জিজ্ঞেস করছো কিছু বলছে হ্যাঁ পেয়ারে আছে with interest মূল্যায়ন করেছে একটা ইন্টারেস্ট দেবে ব্যাংকিং ইন্টারেস্ট you are not pressing prayer B
Where we have not seen, my lord, where we
will any direction be necessary to have an interest banking interest on the amount that has been
I have prayed that.
Are you pressing?
As your lordship pleases. As your lordship pleases. I'm so
Together
grateful,
with-
my lord. As your lordship pleases.
no you have taken it by principal amount together with the interest at the rate of 6% from the date of date of the order when it was taken
That is the point.
from
But from the date of recovery, my lord, date that we
from the date of deduction till refund from the date of deduction till refund
okay. So okay. Also pleased. Now I'm carrying out the correct.
yes page 6 and 8
Item number 6.
State one. And for the state.
I appear for the petition.
ঠিক আছে সব respondent number
I am for the state.
private
I am for the state.
My grievance is, my lord, I am a lessee in respect of a particular property. The lease originally, my lord, was in the name of my father. But after my father's demise, the lease was divided into 6 parts. But the lease was divided into 6 parts between the 6 sons. The 6
so who granted you lease
by the Jila Parishad.
Jila
It's a government land.
I am for Jila Parishad.
It's a government land. I'm a lessee. My lord, there is an
I disputed that.
my lord, there is a lease agreement which I've annexed with my application. My lord, here, my lord, there is a prohibition on making any construction on that land without the permission of the Jila Parishad. So, my lord,
which clause
my lord kindly sees, my lord kindly comes to page 15. Clause 3, it is in Bengali. I do not know.
no,
There
you
is no translation.
read the clause
Yes, my lord, clause 3 is আমি দ্বিতীয় পক্ষ উক্ত জমিতে যে গৃহাদি নির্মাণ করিব তাহার জন্য প্রথম পক্ষের নিকট নকশা দাখিল করিব প্রথম পক্ষ উক্ত নকশা মঞ্জুর করিয়া গৃহ নির্মাণের অনুমতি প্রদান করিলে তবে আমি দ্বিতীয় পক্ষ উক্ত মঞ্জুরিকৃত নকশা অনুসারে গৃহ নির্মাণ করিব তাহার কোনো অন্যথা বা পরিবর্তন করিতে পারব না প্রথম পক্ষের বিনানুমতিতে অক্ত জমিতে কোনো গৃহাদি নির্মাণ করিলে তৎক্ষণাৎ অত্র একরারনামা বাতিল হইবে এবং আমি দ্বিতীয় পক্ষ বিনা নোটিশে উচ্ছেদযোগ্য হইব So this is the clause which prohibits any lessee to make any construction on the land without the permission of the state of the Jila Parishad. Now, my lord, what has happened? My lord, the respondent number 7, who's the private respondent, has made certain constructions on the land which I allege to be unauthorized in nature because they have constructed a 2-storied building on their part of the lease. For which, my lord, I made a complaint, which your lordship will find at page 20. Before the competent authority, I make a complaint saying that there is an unauthorized construction on the leasehold land. There is no permission obtained from the Jila Parishad. There is also no sanction of that particular construction, so that construction has to be removed. But kindly take
private respondents are also lessees
yes
of the
private
same
of the
plot
same, there are the leases have been divided because it was originally in the name of our father. Private respondent is my own brother. Or the legal heirs, it was after the demise of my father, it was divided between all the 6 legal heirs of that father.
Now, my lord, they are also bound by the same terms of the lease, which prohibits them that they cannot make any construction on the land without the sanction of the Jila Parishad.
What is the purpose of the lease?
The lease is for we run shop rooms from that.
Now they are making.
They had made one construction
building.
Two-story building. But that I say is unauthorized in nature, and that is why I make a complaint before the authority. Now that complaint is at page, or the representation is at page 20. Well, that is the next matter. I shall address your lordship on that.
Alleging unauthorized construction by the petitioner. And my lord, Justice Sampasakar has been pleased to dispose the matter and direction to file report to the concerned respondent. Upon giving opportunity of hearing, the concerned respondent had passed the order. They had suppressed the order, my lord. Order that is clear that their lease has been cancelled and they are involved in unauthorized construction. My lord, order is there that in their presence order has been made.
That is a subject matter of the next matter, my lord, which I shall address your lordship on. My lord, in the next matter, I have assailed the report. Yes, my lord, I have impugned that particular report or the particular order by which my lease has been terminated by the Jila Parishad. In the next matter.
And their lease has been cancelled, my lord, and our lease has been renewed, my lord. That lease already been cancelled. Kindly see the order sheet, my lord. They have not annexed, my lord.
Why that something?
The Jila Parishad order. I have passed this order. My lord, order dated 10th August 2023. After that, due to personal grudge, they had filed this thing. My lord, last page. Page 4, my lord.
Concrete first party he did not see
in the light of the above, and after through consideration of the statements and reports made and produced before the undersigned, it is ordered that the construction on the land of Jila Parishad being plot number such and such is unauthorized, and this unauthorized part of the construction be removed within 10 days from the date of order by Nikhil Ranjan Tiplai. My lord,
petitioner.
But the matter will be with the provision of section 160 of the West Bengal Panchayat Amendment Act 2017, and removal of building cost will be realized from the lessee who has made the unauthorized construction. Further, as he violated the lease agreement with the Purva Medinipur Jila Parishad, his lease is hereby cancelled as per clause 3 and 11 of the lease agreement, and no further lease renewal will be accepted. Thus, the order of Honorable High Court is complied with. The order be served upon the interested party.
Yes.
It not perfectly not previously, my lord, the petitioner, my lord, constructed, my lord, on story building, my lord, and my lord, he cemented the same, my lord, roof cemented. As such, my lord, the respondent here made objection. The Honorable Court, the matter came. Honorable Court rejected to hear the matter and so has been passed by Jila Parishad that an inquiry was made by Jila Parishad, and it is found that the objection is correct. As such, it was, my lord, Jila Parishad passed this order for demolition of the said construction. Till then, my lord, we are taking steps, my lord, as the, my lord, some statutory legal, some statutory obligation is there, my lord. We are taking steps to demolish the same. But, my lord, at present, the petitioner is not the lessee of the Jila Parishad. My lord, their lease has been cancelled in 2028, 1428, 3 years before. Now, my lord, as per our order, my lord, we have, my lord, expressly, my lord, observed that his lease not being, his lease cannot be, my lord, renewed because he has disobeyed the, my lord, regulations as mentioned in the, my lord, lease agreement, my lord, license agreement. We have granting license for 2 years only.
Yes.
May I now say that insofar as
Jila Parishad the main authority. Jila Parishad.
May I now say, my lord, this order which has been relied upon, this is a subject matter of the next matter which your lordship will
Next
take
matter
up.
the
In the next writ petition,
Next matter, I have no appearance part of Jila Parishad.
yes, sir.
No appearance part of Jila Parishad, I have not, I am not there.
But I am told, my lord, it has been served, my lord, on all the respondents.
complete the service.
I am not there.
Where is your affidavit to serve? You have not been made a party.
Yes, my lord, that is a mistake on my part. I should have implemented, my lord, the private respondent here as a party in the next matter.
देखिए affidavit. Affidavit of service.
Affidavit of service is there, but it is not showing that it has not been served. My lord, service has to be complete. But I'll
Serve
one
after
thing, my lord, if your lordship kindly
What is
grants me
this?
leave, I'll complete the service. I'll add the private
On the
respondent.
prayer of it item number 7.
I am for the state.
On the prayer of learned advocate for the petitioner, leave is granted to add what is his name?
But I'll tell you. The respondent number 7.
7. Sri Chittoranjan reply as added respondent number 7. Mr. Dasgupta, learned advocate appearing for the petitioner, submits that the service upon the respondents has not been completed as yet. Petitioner is directed to serve.
Given the copy,
Well, may I do this? May I, well, since the learned advocates are appearing for the respective
I
parties,
cannot
serve the
take
advocates?
that in your report because they will have to
Appointed.
order.
Very good. I'll serve them.
They will come with Bhalatnama.
Serve upon the
But as the private respondent is concerned, I can serve the private respondent here.
serve upon the respondent numbers 1 to 6 and file affidavit of service on the returnable date. In this service is complete?
In this one, I'll again check. I'll again check. But they are appearing. All the parties are appearing. In item 6, all the parties are appearing.
It is the stated number near 6 se
7. I am having for the number 1.
এখানে করো 6 নম্বরে on the prayer of the learned advocates for the respective parties, let the matter appear along with WPA 645 of 2024. After it is completed, both the matters can be taken up.
But I'm not filing the affidavit of service. Both the services are incomplete. But I shall file along with it, but then on the returnable date. Fresh.
Mr. Dasgupta 6 accommodation to file affidavit of service 640. Huh?
So far as item 6 is concerned, my affidavit of service is here. But item 7.
File that affidavit of 640 affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Will you be filing any report in 6?
What is there? I have
Only order.
That is a different cause of action. That is insofar as my unauthorized construction is concerned. Thus, the order which has been shown.
Direct, I can file report.
अच्छा मुझे बोलो दो हाँ जिला परिषद रिस्पॉन्ड नंबर who will file 4?
Respondent 4 had passed the impugned order, so respondent 4 shall file the affidavit.
Sir, who will file report?
Jila Parishad.
4. Respondent 4. No, Jila Parishad is not a party. The executive officer, additional executive.
He is the officer of Jila Parishad. He is the additional executive officer of Jila Parishad.
No. Hold on. Huh? 640 তে বলছি 5টা তো হয়ে গেছে, ওই অ্যাফিডেভিট সার্ভিস ওইগুলো হয়ে গেল। 6406 এটা। Respond number 4 is directed to file a report on the returnable date. কবে দেবো? When can this completed? 9th করুন, 9th April। এটা একসাথেই আসবে। রিটার্নেবল না, মোশন দাও, মোশন দাও, মোশন। 10th 24 আছে? হ্যাঁ 10th April।
The Lordship will kindly grant me leave to add the private respondent in the
Granted,
next matter.
leave granted.
But by in hand, my lord.
Yes.
But Lordship has granted that in hand. My lord. Very grateful.
Who is the advocate on record? Do that.
Item number 8.
I am for the petition.
Please also. দেখি কি বলছে। দাও।
Service. One document. I have not anything. Right. There is nothing. I have handed over the copy of the letter. After my library. Document. Annexure 11 is I supplementary.
Shijora Panchayat, Srimani, Golar, Kurshi, Sarpar, Giteni. How many Gram Panchayats are there? What is this case? What is this case?
Guarantee all the picture movement of the doctor. Their panel was prepared. You are not saying the annexure supplementary evidence. 11 is 5. Joint 6.3 passed an order. First line from the last. You are not saying you may either panel from pending are sanctioned by the Health and Family Welfare Department. That document is not annexed by it. That's why I never that you know I have far my last
tomorrow. Release की सब भेज है।
It's 5.
সাইন করেছে 4236 not sir, not 4223 কে এলো 4236 কাশিঝোড়া গ্রাম পঞ্চায়েত not served। 4222 not served। Srimani Gram Panchayat, get a track consignment report of this. This has been dispatched but not served as yet. 4219 4219 কালকে রাখো। Check the track consignment report of the last two. Leave tomorrow, I'll give tomorrow.
No, my lord, your lord can I have five. Again, I have
हम tomorrow কালকে নেব চলো কালকে উপর দিকে রাখো কালকে